This is Privacy on the Ground, where privacy meets real life.
We recently discovered, although we're very early in the process of unpacking that they've been using and developing AI-based tools for several years now. So there's a trend that there seems to be developing of the public and researchers and practitioners and folks learning about these things many years after they started development or thinking about it. So we're playing a catch-up game from day one.
Will Tao knows firsthand how automated algorithmic and machine learning systems used by Canada's government affect lives. The founder of Heron Law Offices in Burnaby, British Columbia, practices immigration, refugee, and citizenship law in Canada. He's watched as these systems automatically determine or inform decisions affecting the lives of his clients, sometimes influencing decisions about whether they can legally work or even whether they must separate from their spouses or children. Because of his intimate experience and knowledge of the effects of these systems and his struggles to learn more about how they work and how they are used inside government, Tao has become a critic, not only of the systems themselves, but of a key approach Canada uses to govern them, the Algorithmic Impact Assessment, or AIA. Tao, along with colleagues in the immigration law community in Canada, in 2023 co founded a civil society group called AIMICI, or AIMACAI, the AI Monitor for Immigration in Canada and internationally. I'm Kaye, World Privacy Forum's Deputy Director. When Tao and I recorded this talk in November 2024, Canada's Treasury Board had just begun a review of the directive that requires use of the AIAs. Its directive on automated decision-making, established in 2019. Results of that review and updates to the directive were just published this June. It will take some further research to understand what is new and how changes might affect the assessment process and, by extension, people like Tao and his clients. A variety of Canadian government agencies have evaluated the automated systems they use according to the country's AIA process, including its employment and transportation agencies, its Department of Veterans Affairs, and the Royal Canadian Mounted Police. The AIA is a detailed self-assessment questionnaire that's intended to determine risk and reduce potential negative impacts of automated systems. Like some other AI governance assessments, Canada's AIA produces a numerical score used to measure the risk level of the system evaluated. That scoring algorithm is based on answers related to a system's design, decision type, impact, data, and more. It assigns points to questionnaire answers. The more points, the higher the risk level. The talk with Tao you'll hear today offers insight into how he and his colleagues have themselves used the AIAs, particularly the assessments from Canada's Immigration Agency, and why, despite the public accessibility of the assessments, Tao considers the use of automated systems by that agency to be shrouded in what he calls a low disclosure environment. Okay, let's dive into this great talk with Will Tao.
My name is Will Tao. I'm the principal at Heron Law Offices. It's a Burnaby, Vancouver-based immigration, refugee, and administrative law firm that I co-founded 3 years ago, and I'm also a co-founder of an organization, civil society, but we're not incorporated yet, called AIMICI, and it stands for Artificial Intelligence Monitor for Immigration in Canada and internationally. Yeah, my work is primarily right now in the space of immigration, refugee, and citizenship law in Canada, and as our area of law has been interfacing with issues of the use of automated decision-making systems and AI, as well as increasing security issues and non-disclosure of information to our clientele. And in their cases, we are involved in increasing efforts to litigate and resolve issues for our clients around these issues. So litigating against the government when these refusals and when these negative decisions are coming down, or when clients run into requests from the government that start to encroach on these type of issues. And generally being a critic of the government's use of automated decision-making systems in the way that they've pursued these projects.
So, yeah, and you found that this was such a regular kind of thing that you're dealing with in your work that you have founded an organization that tries to address use of automated systems, right? In immigration. I mean, is there anything that was an impetus for the
Yes. So I would probably trace the story back 3 years ago, roughly. And that was when a few of us colleagues in our immigration cases started to see the use of a technology called Chinook in our applications. And what Chinook was, at that time we didn't know, but we knew it was leading to these boilerplate template decisions that were leading our clients to have their cases refused, and it seemed like their submissions and their what they tried to represent wasn't being heard by the government. And then we noticed that they were trying to push sort of the strategic litigation upon our clients, and it led to a little bit of a collaboration between a few of us counsel, and we raised this as an issue, and we did podcasts, and we did sort of public awareness around it, and eventually it got picked up in actually the national parliament in Canada. And it was interesting enough because of an issue in Quebec, and Canada has we have a common law and a civil jurisdiction. We have Quebec has their own set of laws, and Canada as well, and of course there's some shared overlap. But it became a political issue when francophone students in Quebec, largely African students, were being refused at a higher level, and statistics were showing this discrepancy. And then the parliament decided to investigate, during which time the use of this tool and technology that seemed to be accompanying or at least correlating to these changes there was more scrutiny around it and more questions asked about it. So it started with this tool. I initially called it, I thought Chinook was AI, and I said there was a lot of, elements of automation in it. The government has come out quite strongly against that position, saying that it's not AI and it's just a tool that displays cases in a different way for efficiency. We're still in ongoing debates. There was a recent federal court decision in Marara where Justice Batista weighed in and found it wasn't procedurally unfair, but questions still exist about how they're using technology and bulk processing tools. And in uncovering and unpeeling this onion, we also began to learn more, and also the government began to disclose more about their use of advanced analytics and risk flagging tools that are actually AI and utilize automated decision making.
right? And so, just to cap that talk about Chinook, I understand it's a Microsoft Excel spreadsheet based tool, right? And so it's kind of an example to me of how simpler algorithmic systems that people don't think of as AI can have the same kind of impacts, or can be used in a way that automate decisions that would normally be made by somebody, a government staffer or someone else, and they create important, sometimes harmful impacts in ways that a lot of times we just think, oh, that's the really big foundation models that do that, and it's not these little simple systems. And it's just I think it's just such a good example of how, you know, something that seems really simple can have these potential really significant impacts.
That's a really good point, and I think that's where, immediately when you use it, and that's why a lot of folks don't even like to use the word AI in this, right? They call it machine learning, or they call it, you know, non-machine learning based automation, just based off of rules and so forth, because we have to go back to foundations, and a lot of this is, stuff and not necessarily even advanced technologies. These are things that have been used for many, many years, but they've had minor tweaks to it. They've been introducing it slowly, and they're still very imperfect, right? And they're still very rudimentary in many cases. So there is that world of the tech folks, tech solutionists who want to bring in the big language of all these things that are going to go on, general artificial intelligence, but we're not there in the decision-making space in immigration. We're still dealing with very rudimentary, rules-based. Although, again, increasingly they are using advanced analytics. They're using different tools that involve less human interaction and perhaps less humans in the loop. But it comes down to what the underlying basis of that data is, and what the instructions are that being provided to the decision makers. So very, again, rudimentary things that they were doing beforehand scaled up, right?
So that's just one example of many tools or, machine learning models, tools that are used by the Immigration, Refugees, and Citizenship Canada, IRCC, the agency that you really engage with probably the most, I'm guessing, in your work.
Yeah, although I'm doing parallel work about Canada Border Services Agency, and they are our enforcement, our branch and arm of immigration. They do the borders as well, and we've learned more about their security screening automation projects, facial recognition tools, and we're developing a similar app to the United States with alternatives to detention, that uses facial recognition. So there's that angle, and then there's the Immigration Refugee Board. So even our tribunal that deals with refugee claims and appeals, and we recently discovered, although we're very early in the process of unpacking that they've been using and developing AI-based tools for several years now. So there's a trend that there seems to be developing of the public and researchers and practitioners and folks learning about these things many years after they started development or thinking about it. So we're playing a catch-up game from day one.
So one of the things that you and the other immigration lawyers that you work with have used as a way to try to get some transparency or understand what systems are being used, and to try to understand their impact on your clients is Canada's algorithmic impact assessment process, right? And so, um, talk about why those assessments have been important in your work.
Yeah, I think the primary reason is that with this low disclosure environment that we're in, where the government really doesn't provide all of the stuff in Canada, really on the operation level, is hidden in these algorithmic impact assessments that are actually quite hard to find for the layperson, right? You have to really search up in open government this tool, and then you have to click this link to that link. It's not even like a formal link you can easily share sometimes, and you get to a document that lays out at least the final post-deployment, I will call it, version of what was approved and what was looked at by the Treasury Board Secretariat in approving these projects that the government has put in place. They are, the directive itself, and this AIA that's part of the directive on automated decision making, is a soft law tool. It's a directive. It doesn't. It's not judiciable. It's not enforceable. It really is a low bar, and even IRCC in their own assessment and their own governance has said, these are just low bar requirements that we have to meet. But they are at this stage the most transparent window we have to how these tools actually function and how we're able to actually advise our clients about the existence of these tools. Because Immigration has shifted in many ways over the past 2 decades. And even before I practice, I'm about a decade in practice, but between sort of right before I started and maybe the sort of 2 decades ago, immigration was done by officers flying, by lawyers flying to overseas visa offices and having a negotiation with visa offices in person about their clients' outcomes, which today, if you think about it in like an ethical lens, it's like you'd have to choose which clients of yours were approved and refused. That automatically creates, major ethical issues for your professional responsibility and obligations. But that's how immigration was done in the past. In the decade since I started, I came in sort of right when technology was really shooting off into the use of web-based systems, online applications really started to kick in. Our major PR portal started right when I started as a lawyer in 2015, the Express Entry system. And in the 10 years since, we've moved now to this sort of use of ADMs and automated decision-making systems. So I think it has to be contextualized in also this shift towards where we are now. And the AIA is our window into what it is now that they're trying to do.
Have the AIAs affected how you approach any cases or client situations or like interactions with IRCC?
Yeah, I mean, they're very effective, especially in litigation. So I do a lot of judicial reviews of refused decisions where I do have to go to court and show a decision was unreasonable or unfair. And having these AIAs as, things I can bring in as exhibits to an affidavit to explain the foundation of how these decisions are being made. I do feel like there is an educating the court piece that we are currently in the midst of, because courts themselves have traditionally dealt with an administrative law framework around human decision making that doesn't necessarily accord with the way that decisions are actually being made now. So we're trying to bring in that education piece, and the AIs have been very helpful. And the other way is to do our own client advising, because clients at this stage still feel oftentimes that it is a human process, even though that the technology is being involved. They think that hiring a lawyer who can make these representations for them to a decision maker who is a human decision maker will mean that those materials will be taken into account, that they will have a fair shot, that they'll have, even the fact that many people think it's a first in, first out system for applications, or that someone's going to spend, significant time reading their materials. These are all myths that I have to debunk now with the current use of these tools. So that I think I'm professionally responsible for giving them adequate information about how the system works. And I think it also on my ends alleviates when those negative outcomes do inevitably occur, it's outside of my control in a lot of these cases, how these things are being dealt with.
You actually were, I had spoken with you earlier about a specific assessment of a tool that IRCC, I believe, actually built internally it was a tool used to automate triage of processing of applications for Canada's International Youth Work Program. Yeah. And that was an interesting one to you because it incorporated, or it actually, in addition to the assessment that must be published according to the directive, the IRCC also published an adjacent analysis called the Gender-Based Analysis Plus. And what about that? It seemed as though that turned out to be important for you and might have had some, I don't know, helped you gather some information that you hadn't had in the past.
Yeah, so in the last iteration of the Directive on Automated Decision Making, which includes the Algorithmic Impact Assessment, goes to review every 2 years. So actually, we're coming up on another review period cycle coming up for next year. And in the last review process, they added this requirement to do a gender-based analysis plus. This has been a tool that's existed for many, many years in Canada. There are questions as well about its origins and roots, and whether it's a thorough enough lens, whether it's an intersectional lens, and for sure it's had its fair share of critiques. But at the core, it does put some of the issues on the table as to equity issues with these tools. And for that particular algorithmic impact assessment, they did publish statistics based on gender. They did publish some statistics based off of, I believe it was country of citizenship, and other aspects. And putting out statistics and data is very crucial to our ability to recognize or try and point at whether there are some deficiencies. However, that being said, it's the only AIA where they've actually published it, which and because of the functioning of that tool with a very high approval rate and only 2 tiers, it to me seemed like a very strategic release of a report for a tool that was generally a lower risk, lower impact tool. So in doing so, yes, it showed compliance, but it also raised the question of where is this report for all the other tools, especially the ones that have higher impacts, that are actually putting folks into high risk baskets as opposed to just sort of 2 baskets. And what other discrepancies exist in those types of reports. And they also had a peer review, I believe, on that one, and that's another issue. And we've been consulting with the government. They've asked us to provide some feedback on their peer review processes.
Just a quick note here. In Tao's response to my question, he mentions peer reviews. These reviews are required when AIAs score the impact level of an automated decision system at 2 or higher. The idea behind these peer reviews is for agencies to consult with other government experts, researchers, academic faculty, or industry to review the system they aim to use. That new update to the directive on automated decision making and AIAs that I mentioned earlier, it actually includes a noteworthy change to the peer review process. Now, agencies must publish at least a summary of the review before the automated decision system is produced.
But one of our central complaints on peer review is that what we get from a peer review publicly is a copy of the actual. So this is IRCC's summary of what the peer review of that other government body was. So you're hearing it from someone who's filtering those comments into what they want the public to know about it. And to us, we should be able to see the actual peer review of that party. And when we do have, and we have shared, because we've obtained these documents through access to information, the actual comments from these third parties, they're much more critical, and they point to questions such as, is there possible automation bias? Is there possible issues with the training of these officers with the respect to these tools? Things that go to the core of whether these tools may be problematic. But a lot of that information, when it comes to the summaries provided by the institution who was seeking to get the project approved in the first place, removes that information or removes that layer of concern from what they publish. So we are definitely in our advocacy calling for the release of more documentation, more data. The flip side of it from the government's perspective is, if you give more data, will folks be able to game the system? Will our system be subject to integrity issues? Are there national security concerns if suddenly, the data shows there's, we're treating a certain country of citizenship in an adverse way that could lead to international relations issues, which are now part of non-disclosure sort of mandates and in different aspects. So I do get the government's perspective on this, but from like an applicant's perspective, or from those seeking to try and improve these systems and scrutinize them, it's hard to scrutinize what you can't see and what you don't have access to.
Are there changes that have been made to the AI process? There has been some evolution and some changes since it was originally created. It's evolved a little bit. Have you seen any changes made that were either in response to requests that you've made, or just that have been beneficial that you would point to?
So I think we're already starting to see it a little bit, and I think in our peer review guide, for example, one of the things things that I was calling for was a bit more of a specification of the role of the humans in the loop. Who are they? What are they actually doing? How are they trained? And it seems like some of those comments have made their way into this revised peer review guide that the Treasury Board Secretariat is working on, that's now being provided to um, or I don't know where it's at its approval stage, but it'll be provided to the departments completing the assessment. So before they would not have to expand on those points, and now this new peer review, this new AIA guide is asking for more of those details, right? So sorry, I correct. I think it's the AIA guide that has the information now asking about the humans in the loop. Even with the peer review, like our major input point on this was that we need to see the transparency from the department actually providing the comments and to do that. And that hasn't been actioned yet, but I think it's at least on the table. So the next time when we have the 2-year review, that we can anchor ourselves to some previous submissions that we've made. I do suspect that the bulk of things that will change or improve or be different will occur in the next revision of the AIA that's coming up in 2025. One thing that I'm really hoping for that I feel needs to be involved in that process is a notice and comment. And I know in the United States that's a major. It's legislated for regulatory amendments. In Canada, because they've taken a lot of this out of the usual regulatory scope and they've put it in this sort of soft law directive, it's been able to avoid any sort of notice and comment process. And one thing I'm hoping for is in line with the best practices of AIAs. I believe it was in the Resman and Crawford piece that they talked about it, but having a period where folks can challenge and can provide feedback that could be taken into account, I think is a bare minimum. The way it's happening now is they're publishing only the final versions of these after the projects have already been deployed and approved. So we're really just seeing it at the back end. And there seems to be very little impetus to revise these AIAs on an ongoing basis as they're supposed to be doing. What I would like to see is, as soon as the project is being pitched or proposed and in draft form, that these drafts of these AIAs are being made available to stakeholders so that we can comment on them as they are getting these projects approved, as opposed to just on the back end sort of letting us know, hey, we have this project now, like, deal with it, which seems like to be the way that it's the rubber stamping that I talked about, and I believe in our last interview. I feel very strongly that that's what it is right now, at least.
You mentioned human in the loop and sort of this idea of how humans would be part of a process of use of an AI tool or use of a machine learning or some sort of algorithmic process. So that concept is something that I'm seeing in some other work, some other analysis of AI governance tools that we've been looking into at World Privacy Forum. And in fact, in Chile, their approach to assessing AI systems used by their Social Security, health insurance agency, they kind of came up against some of the same issues where the assessment process that was necessary to, as part of the procurement for AI systems, and this was specific to processing of medical claims, determining whether or not somebody can get coverage for their work time, basically get their salaries paid while they're on medical leave. It's, do they get that claim approved or not? And so there was this question that has come up where, or at least some gaps have been exposed in terms of how the procurement process and the assessment of an AI model addresses this human agency question. And they basically are saying, we don't have anything in this assessment that helps us figure out whether or not, even after we've assessed the model's fairness, is it explainable? Is it protecting data privacy and things like that? They still were really wondering, how are we supposed to actually employ it? Can it be employed in a way that is completely automated and it's totally automating that medical claim decision? Or should it only be used to inform a decision that's made by a human? And so that was an interesting thing to see that they're grappling with. And it seems as though that's an issue in Canada too. And it's not necessarily being addressed in the AIA as it exists
So
today.
right now with the AIA, as it stands, with low to medium risk projects, there's no requirement for a human in the loop. The impact, the low to medium impact. The impact itself is being self-assessed by the department that wants to get the project approved. So to date, all the projects, regardless of what it's touched upon, has been self-assessed as low to medium risk. So we really haven't, other than a single line in these AIAs that say no human in the loop is required, although ironically later on in the description and stuff, they talk about how humans are involved in the final decision. So it's almost kind of self-contradictory in these documents too, if you read them kind of carefully. But that's the frameworking issue, at least. I'm also running up against another more theoretical issue, and this has been really helpful because I recently took a course. I'm doing my Master's of Law right now at Allard, and we had a visiting Professor Aziz Huk from the University of Chicago, who's written a very, very engaging paper on the right to human decision, where he set out to argue that there was a right to human decision, but as he wrote the paper, he found out he couldn't justify it or ground it in U.S. law, nor in sort of the empirical evidence that he was reviewing. And some of his findings are around the fact that humans in the loop or humans involved in machine decisions can actually make the outcomes worse or less accurate. So even that empirical question, I would say, in Canada at least, is, for whatever reason, we haven't had the same studies that the US has had in areas such as welfare or incarceration, or the use of these tools in sentencing, where we can kind of point to perhaps the fact whether a human in the loop has actually helped or harmed the effectiveness or the accuracy. And again, accuracy itself is a contested term depending on where you view it in a computer science way or in a anti-bias way and so forth, in like a social bias perspective. But in Canada, we've got this like lack of empirical evidence altogether. So when someone says that the government justifies that a human in the loop is a safeguard and it'll make things more accurate, we don't have any way to test that, right? And if they say there's no need for human in the loop, similarly, we have no way to test that. So I think we're existing in, at least in Canada, in an empirical vacuum around how these tools are actually being operationalized and whether and how the role of the human in the loop is supposed to help or harm that system. So I do hope that that's an area that we need some real data scientists involved to really start doing that testing, conduct experiments, and really help understand that problematic.
So, but you mentioned just the overall approach of the AIA, which is really important, I think, just to talk a little bit more about, which is that it's based on this idea of it produces, it's essentially a set of questions, right? And it's a set of questions that the agency, in the case of, as we've been discussing, the IRCC or whatever agency it might be, the education department or whatever it is, answers those questions. According to the answers, each question has kind of a number of points depending on how it's answered, and it's all put together, and a score is given, and depending on that number, there's a high, medium, or low impact level that's determined based on that. And that seems like a really, I don't know if there's anything that you'd want to say about that approach, and whether you think that's because I think that you referred to the fact that, at least from what I can see, there have been no high impact assessments, right? Everything's fallen into low or medium impact. And so they haven't really gone to that point where, like, oh, there have to be these more stringent kind of restrictions or mitigations or whatever as a result.
Yeah, no, and that's where one of my concerns lie. It's, when you don't have a independent third party or a non-governmental body that's involved in the scoring process, or at least in challenging it, right? I've seen correspondence on some of these approvals, and it's, through emails or through folks jumping on things last minute, or, questions that, here, I have a concern about this area. Can you clarify? And some clarifications provided that from an outsider perspective, I'm like, this clarification is not suitable, accurate, represents from practice. But it's just taken for face, and then suddenly, okay, we approve, we can move ahead. But the fact that someone who wants a project being approved and has a mandate for efficiency purposes or whatever financial incentives, could be contracts with third parties, to have a project approved, and they're the ones giving themselves a score for how they think that project's going to impact, knowing if they give it a high score, that project will be delayed, or that project will face additional governance measures. It has this feeling of like uh, giving yourself participation marks in school kind of feel, where it doesn't seem very meaningful, and it leads to skewed results. Sorry. So I would definitely recommend some way of external parties being able to at least participate, right? And at least plant some ideas, or counter, right? That this contestability idea that's always in AI. Like, if someone's saying that there's going to be this outcome and it's a low impact because no one's affected, and at worst someone's going to miss a meeting because their visa will be denied, can there be at least someone in the voice in the audience be like, well, no, families are being separated because of that visa, or, mental health issues have spiked, or at least point out some of the externalities that those who are trying to pitch the project, get it approved, are either missing because their minds are not turned to it, or purposely omitting because they don't want to cause scrutiny to their own projects. So I think there's a huge gap there to be filled with good governance.
Have you seen any indications that there could be a time where third parties, external entities might be part of the AIA process or some other related process?
I'm seeing a little bit of hope in the revised AIA guide that they're working on and we consulted on. They're asking about some of these, especially international law compliance issues, persons with disabilities. They seem to be expanding the scope of considerations, and requiring departments to at least meaningfully engage more. But I think it really will come down to what happens at the next review, and who's at the table. And I mean, that's another thing in terms of feedback I'd have, is they've run the previous consultation processes really. I do feel very fortunate to have been at the table, but I think it was an institutional relationship that allowed me to get an invite to provide some comments, right? And it was very much, this is due in 3 weeks. We have this thing, provide some comments. We didn't have any interaction, or we didn't know whether stakeholders were at the table. We didn't know what the directed questions were for this consult. So it's like, hey, read this long 70-page document and tell us if there's any problems. Like, well, so I hope whatever way that, because I know the roots of this, and it's documented in Petra Molnar's brilliant work, Bots at the Gate. When they came up with this initial project, it was groundbreaking, bring different people from different fields together to discuss this new innovative directive. Somewhere down the line, and I'm hoping I'll see it because I wasn't part of the last review, but maybe this next one is the similar type where we're actually all in the same room, or at least a virtual room together, and we can start asking these difficult questions of each other, as opposed to just sort of, hey, here's a comment period, and like, let me know your thoughts, and then whether or not they're incorporated is out of our hands. I think um, that's something I'm looking at moving forward, if there could be something more meaningful and robust in taking into account our critiques.
That can be frustrating. I think I feel you there. um, so the algorithmic impact assessment was developed as a result of the 2019 directive on automated decision making. And in that document, it states that the directive is intended to ensure that automated decision systems are deployed in a manner that reduces risks to clients, federal institutions, and Canadian society, and leads to more efficient, accurate, consistent, and interpretable decisions made pursuant to Canadian law. Do you think the AIAs are helping accomplish those goals?
Yeah, and that's, a core question when you talk about these projects too. It's, from an applicant's perspective, critiquing it or falling on the wayside or user-based being spit out or rejected or having an application delayed. You have a very different perspective than maybe a more government enforcement, security, efficiency driven approach, right? Because if that's your mandated and it's sort of written in their efficiency and you're able to save money and make more decisions and filter folks out based on risk level, I mean, from your perspective, maybe things are working perfectly fine, right? So I think that there is it is a clash, and the question then becomes, how willing are they to have an ear to the concerns of the users who do not feel the systems are delivering on those same things, or they may view those criteria differently. And I'll give you an example of efficiency, right? And it's not a perfect example, but if it's efficient for those 20%, 30% that are being skimmed off the top and being approved, have their eligibilities approved, but for the rest of the folks, the 70% or whatnot, who are being deemed medium or high risk because of the use of these technologies, and then they're sitting on a desk of a human officer who has the outputs of these technologies. And of course, they're supposed to be safeguards so they don't know everything, or they're not, privy to all the information. But those files are sitting because of some of these outcomes, be it a risk flag or security assessment, and they're known to be medium high risk because they haven't had their eligibility approved. And then you have a country that is reducing the size of its immigration population and creating essentially caps for a lot of these different areas. You're going to fill them with the low risk cases. You're not going to fill them with these more difficult cases. So they're just sitting in offices, and now people are waiting several years for any movement on their file. So efficiency for the government because they've been able to get the 30% that they want, yes. Efficiency for the person who is sitting years separated from their loved ones or in the state of flux because of some assessment they have no clue of and some output that a ADM system has helped influence and put on record, and no. So I think that's the foundational challenge, is whether they're willing to hold on to these different definitions of these meanings and perspectives from the different stakeholders.
I just can't stress this enough. It's talks like these with people like Will Tao that are crucial components of research and analysis of AI governance tools. So I'd like to thank him for taking time out of his demanding day to share his experiences. In our next episode of this AI governance tools series, I'll share with you the latest installment of our World Privacy Forum research on real-world use of AI governance tools. Work I got a chance to present recently in the Netherlands at the 4th European Workshop on Algorithmic Fairness. Stay tuned, and thanks for listening to Privacy on the Ground.